All right. Well, greetings, everyone. I want to thank you all for participating in this CLE presentation sponsored by the Christian Legal Society. So whether you're from the Colorado Springs chapter or the Denver Metro chapter or wherever else, we're glad that you could join us. My name is Joe Brown, and I'm an attorney here at Teleos Law in Monument, Colorado. Many of our clients at Teleos Law are religious organizations of one stripe or another, so it's fair to say that our practice deals with many issues at the crossroads of law and religion, not least of which is the topic we'll be discussing in this presentation, namely religious liberty litigation. So let's tear right into it. The opening words of the First Amendment read, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof." These 16 words are among the most controversial in our Constitution, and they've profoundly influenced American jurisprudence, politics, and culture. Now, the language of this amendment raises several questions. First, the text says, Congress shall make no law establishing religion. What about state and local governments? What about executive orders from the president? Do those count? Second, what is a law for purposes of the First Amendment? Does make no law include things like administrative regulations, government spending, public displays, government speech like license plates and road signs? Third, most scholars recognize two distinct clauses in this sentence, the Establishment Clause and the Free Exercise Clause. So how do these clauses relate to each other? Do they overlap? Are there ways that they might conflict or be in tension with each other? Fourth, what is the exercise of religion, and is that different than the practice of religion? And lastly, what is religion for purposes of the First Amendment? So these are some of the foundational issues that our courts still grapple with and which divide legal scholars and practitioners. While this presentation will not attempt to fully answer these questions, I hope it will give you a glimpse into the issues and what your interest in the First Amendment. Now, what I hope that you as an attorney get out of this presentation is, first and most importantly, I hope that you are better able to identify and respond to any religious liberty issues that arise in your own practice. Second, I hope that you have a greater appreciation for how dynamic and complex this area of law is. And then lastly, I hope this presentation helps you to better understand your own rights as an American citizen. So the presentation will have two main parts. The first part is kind of a broad 1,000-foot overview of the various areas of First Amendment precedent. And the second part is an update on recent and current religious liberty litigation in the federal courts. Religious liberty is an area of law that is somewhat difficult to understand if you don't have a decent grasp on how the legal framework has evolved over time. That's why I want to cover some of the history of how the law came to be what it is today. Otherwise, it's kind of hard to understand what's at stake in the current litigation or to contextualize current litigation in the ever-changing stream of First Amendment jurisprudence. Now, the first precedential area I want to discuss is that of how the First Amendment has historically applied in the constitutional scheme of federalism. Now, what do I mean by federalism? Federalism describes the relationship between the state governments and the federal government under our constitutional framework. As you know, our system of government is one of concurrent sovereigns, where we have both the federal and state governments, both of which are restrained by the Constitution. There are things that states are allowed to do that the federal government is not allowed to do, and vice versa. In terms of the First Amendment, it's rather clear that the framers of the Constitution did not originally intend for the Bill of Rights to apply to the states, but rather only to restrict federal power. However, after the Civil War, the victorious Northern Republicans wanted to ensure that state governments recognized and respected the civil liberties of all citizens. The result was the ratification of the 14th Amendment in 1868. Section 1 of the 14th Amendment provides, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law." nor deny to any person within its jurisdiction the equal protection of the laws. So if you've ever encountered references to the Privileges or Immunities Clause or the Due Process Clause or the Equal Protection Clause in your practice, those are the three clauses that I just read to you. Now, while it doesn't say so explicitly, nearly all scholars agree that the 14th Amendment effectually incorporated the Bill of Rights to the states. Therefore, what the 14th Amendment did was it extended the application of the First Amendment beyond just Congress and applied it to state and local governments. Or did it? One indication that perhaps the 14th Amendment did not apply the religion clauses to the states is actually a failed amendment to the Constitution known as the Blaine Amendment. This amendment was introduced by Congressman James G. Blaine in 1875. You'll notice the first sentence of the amendment, "No state shall make any law respecting an establishment of religion or prohibiting the free exercise thereof," reads almost verbatim like the First Amendment's religion clauses, with the important difference that this amendment explicitly applies to the states rather than to Congress. Now, you'll also notice that the rest of the amendment's text pertains to the support of public schools and the funding of public land. So what's that all about? Well, it was during this period when the United States was seeing mass immigration from Ireland and Eastern Europe, most of those new immigrants, of course, being Roman Catholics. And when those new Catholic immigrants came here, they sought to establish their own churches and schools, and in many instances vied for public support against the established schools, which were decidedly Protestant in their orientation. Now, many Americans understood the country's fundamental cultural and civic institutions to be essentially Protestant in character. And they saw the growth of Roman Catholicism to be an existential threat to the Republic itself. Now, if you've ever seen the movie Gangs of New York, that's a rather decent Hollywood depiction of the kind of culture conf that was going on in America at that point. So during this era, there are no shortage of political cartoons like the one pictured here that portrayed Roman Catholics as fundamentally a threat to the American way of life. So it's this anti-Catholic bigotry that was the impetus for the Blaine Amendment. The Blaine Amendment was intended to prevent newly formed Catholic dioceses from being able to obtain public support for parish schools and other infrastructure. Now, this amendment was wildly popular. It passed the House by a vote of 180 to 7 and was only 4 votes short of the 3/4 vote necessary to pass the Senate. Now, if it had passed, it would have certainly enjoyed the support of then President Ulysses S. Grant, as well as most, if not all, of the states. This is evidenced by the fact that when this amendment failed in Congress, nearly all of the states adopted their own form of the Blaine Amendment into their own constitutions. Today, 40 of the 50 states have some form of this amendment, which is important for current cases we'll discuss here in a moment. The fact that this amendment was even proposed 7 years after the ratification of the 14th Amendment casts doubt on the notion that the 14th Amendment incorporated the religion clauses to the states. If that's what the 14th Amendment did in 1868, then why would this amendment have even been thought to be necessary in 1875? So the million-dollar question then is, did the 14th Amendment actually incorporate the First Amendment's religion clauses against the states? And the answer is yes, actually it did. We know it did because the Supreme Court has held now for about 80 years that these clauses do apply against the states. This was first established in a 1940 Supreme Court decision, Cantwell versus Connecticut, which held that the Free Exercise Clause was incorporated against the state. And Cantwell was followed just a few years later by the court's decision in Everson versus Board of Education, which held that the Establishment Clause was incorporated against the states. So the 1940s were somewhat of a watershed moment for the religion clauses. Before these two decisions, there had been very little litigation under these clauses. But now that it was clear that state and local governments were also bound by the First Amendment, not just the federal government, this opened up a much broader channel of litigating religious liberty claims. Now, this coincided with a demographic shift in America from a country that was homogeneously Protestant to a country more defined by multiculturalism and religious pluralism. This also coincided with a transformation of the federal bench toward a disposition of judicial activism. Federal judges began to adopt a more expansive view of civil liberties. In the 1950s and 60s, the federal courts, particularly the U.S. Supreme Court under Chief Justice Earl Warren, started to have a much more significant influence on American civic life. The result of these coinciding phenomena was a litigation explosion for constitutional civil liberties. And religious liberty was not exempt from this legal revolution. Starting in the 1960s, the federal courts began to interpret the Free Exercise Clause very expansively in a way that really gave the clause teeth. There were a succession of Supreme Court cases that subjected government burdens on religion to the most stringent level of judicial scrutiny. Sherbert versus Werner and Thomas versus Review Board both involved persons who had been terminated from their employment for reasons related to their religious convictions. Sherbert involved a Seventh-day Adventist who refused to work on Saturdays and was terminated. Thomas involved a pacifist, Jehovah's Witness, employed at a steel mill who refused to assemble turrets for army tanks, and he was also fired. Now, in both of these two cases, the state agencies administering unemployment benefits denied benefits to the plaintiffs because they had been terminated rather than simply laid off. The Supreme Court in both cases said that such denial violated the Free Exercise Clause because it effectively forced the employees to choose between receiving a government benefit and exercising their religious convictions. Now, it wasn't unconstitutional that they were fired, but it was unconstitutional for the state to deny them unemployment benefits because of the religious reasons for which they were fired. Now, the case that transpired in the middle, Wisconsin versus Yoder, that case involved a state law requiring compulsory school attendance for all children through 12th grade. This violated the religious beliefs of the Amish community, who established their own schools and enrolled students only through the 8th grade, after which Amish children were expected to work and to contribute to communal life according to Amish beliefs. The Supreme Court also struck this law down. Now, the essential holding of each of these three cases, Sherbert, Yoder, and Thomas, was the rule that government burdens on religious exercise are subject to strict scrutiny. Now, what do I mean by strict scrutiny? Well, in case you're not a constitutional practitioner and it's been a few years since law school, strict scrutiny refers to the most stringent level of judicial scrutiny under the 14th Amendment. Under the Due Process Clause and the Equal Protection Clause, courts have developed a scheme of tiered scrutiny to review categories of state action that burden civil rights or discriminate against certain classes of persons. So under the Due Process Clause, courts have said that there are some liberty and property interests that citizens have that are more important than others. There are some liberty interests the court has recognized as being fundamental rights, such as the right to free speech, the right to travel, the right to parent, the right to marry, etc. The government simply cannot burden these rights unless it has a very compelling reason to do so. Likewise, under the Equal Protection Clause, the government is allowed to treat people differently for some reasons, but not for others. For instance, the government can treat high-income people differently than low-income people in the way that it taxes or distributes benefits. However, the government cannot treat people differently on the basis of their race unless it can prove a very compelling reason for doing so. This is because race is a suspect classification for equal protection purposes, and income is not. So for both substantive due process and equal protection analysis, courts have developed a system of tiered scrutiny to review the constitutionality of government actions. Now, I've provided a table at the very last page of the handout that I've put in the chat that really explains this a lot more in detail. So the lowest level of judicial scrutiny, the one that is most deferential to the government, is rational basis review. Now, under rational basis review, a law or policy is presumed to be constitutional unless a plaintiff can show that the law or policy is absolutely irrational and illegitimate. Now, this is a very heavy burden to meet, And that's why the government will virtually always win under a rational basis review. It's been done before in a handful of cases, but when rational basis review is applied, the government is most likely going to win. So rational basis review applies to burdens on liberty or property interests that are not fundamental rights, and also applies to discriminatory policies that do not discriminate against a suspect class like race or national origin. The second level of judicial scrutiny, intermediate scrutiny, applies to what the courts have called quasi-suspect classifications. Those include things like sex, illegitimacy, and arguably, under the case law, sexual orientation. So under intermediate scrutiny, a government action will be upheld as long as the law or policy furthers an important government interest by means that are substantially related to that interest. Now, the third and most highest and most stringent level of review is that of strict scrutiny. While rational basis review is the most deferential to the government and provides a rebuttable presumption of constitutionality, strict scrutiny is the least deferential to the government. And it presumes that a law or policy is unconstitutional unless the government can show that its policy is, one, necessary to furthering a compelling state interest, two, that it is narrowly tailored to achieve this compelling purpose, and three, that the policy is the least restrictive means to achieving this purpose. Now, as you can see, strict scrutiny imposes a very onerous burden of proof on the government. When strict scrutiny is triggered, it is often a constitutional death sentence. Now, what triggers the application of strict scrutiny is either laws that burden fundamental rights like speech, travel, parenting, marriage, etc., under the Due Process Clause, or laws that discriminate on the basis of suspect classifications like race, national origin, alienage, under the Equal Protection Clause. Now, in terms of religious liberty in the Free Exercise Clause, under the rule from the Sherbert and Yoder and Thomas line of cases we just discussed, religion functioned as both a fundamental right for purposes of substantive due process and a suspect classification for equal protection purposes. This meant that whenever the government enacted any law or policy that burdened religious exercise, even incidentally, it was subject to strict scrutiny. And of course, this meant that under the Sherbert, Yoder, and Thomas rule, the free exercise of religion enjoyed very strong protection from the courts. However, this all changed with the infamous case of Employment Division versus Smith in 1990. Now, Smith involved two employees at a drug rehab facility, both of whom were adherents of a Native American religion. The rituals in this religious tradition involved the ceremonial use of the psychotropic drug peyote for spiritual enhancement. Now, when these two employees were fired for their participation in these religious ceremonies, they were subsequently denied unemployment benefits by the state of Oregon on the basis that the reason for their termination was their use of illegal drugs, for which religious consumption was not an affirmative defense under Oregon law. So these two employees sued Oregon's unemployment agency, and the case eventually came before the U.S. Supreme Court. Now, one would have thought that since this case was so factually similar to Sherbert and Thomas, that the rule would be, and the result would be the same. In both of those cases, the court ruled that it was unconstitutional for the state to deny unemployment benefits to persons who were fired because of their religious practices. Now, under the Sherbert and Yoder and Thomas line of cases, this case, Smith, should have had the same outcome. However, the Smith decision, authored by the late Justice Scalia, held that when the law or policy burdening the exercise of religion is a quote unquote neutral law of general applicability, then such a law is only subject to rational basis review and not to strict scrutiny. That is to say, when a law is neutral as to religion and does not target religion, then such a law is presumed to be constitutional, even if it has the incidental effect of burdening religious exercise. Of course, you can see how the Smith decision was a rather tremendous setback for religious liberties, one that really dulled the teeth of the free exercise clause. This is because it's difficult to imagine laws that are not neutral and generally applicable. For instance, the government is not going to say expressly that there are one set of traffic laws that apply to Catholics and another set that apply to Jews. Laws like that simply do not exist. However, when there is one so-called neutral, generally applicable set of laws, like traffic laws, for instance, there will be religious minorities, such as the Amish, whose exercise of religion might be substantially burdened by these laws. Now, before Smith, many understood the free exercise clause as protecting religious minorities from even the incidental oppressions of majoritarian democracy. However, while Smith did not actually overrule or abrogate the Sherbert, Yoder, and Thomas line of cases, it nevertheless carved out an exception that effectually swallowed the rule. So legal scholars and politicians alike were very displeased with the Smith decision and its significant curtailment of the free exercise clause. So in response, lawmakers in Congress created legislation that was intended to reverse the effect of the Smith decision and return to the Sherbert, Yoder, Thomas rule of strict scrutiny. This legislation was known as the Religious Freedom Restoration Act, or RFRA for short. What this legislation did was require all government actions, state and federal, that substantially burden religion to be narrowly tailored to a compelling government interest. In the legislative purpose section of the bill, Congress explicitly says that its intent was to overrule Smith by statute and return to the Sherbert, Yoder, and Thomas rule. Now, RFRA was introduced in the House by then Congressman Chuck Schumer, and a companion bill was introduced in the Senate by Ted Kennedy. Now, to give you an idea of how popular this legislation was, RFRA passed the democratically controlled House unanimously and passed the democratically controlled Senate by a vote of 97-3, after which it was signed into law by President Clinton in November of 1993. Now, I want to take a moment just to appreciate the irony in all of this. So, an anti-religious court opinion authored by the notorious God-hating secular humanist Antonin Scalia prompts neo-Victorian theocratic Puritans like Chuck Schumer and Ted Kennedy to pass legislation protecting religious liberty, which is then signed into law by that great moral reformer, William Jefferson Clinton. It's quite ironic. So even though it seemed that RFRA reversed Smith and that the strict scrutiny standard for religious liberty was restored, alas, nothing gold can stay. In 1997, the Supreme Court held in the case of City of Bernie versus Flores that RFRA could not apply to the states. Now, it's important to understand that this case was not directly about religious liberty or the free exercise clause, but rather about Congress's powers under the 14th Amendment. Now, earlier you saw the text of Section 1 of the 14th Amendment, which contains the substantive clauses of the amendment that limit state power. Well, Section 5 of the 14th Amendment is the provision that gives Congress an enumerated power to enforce the due process and equal protection clauses by, quote, appropriate legislation. Now, the basis of the court's decision in City of Bernie was that in enacting RFRA, Congress had exceeded its enforcement powers under the 14th Amendment, because what RFRA was trying to do was actually modify an existing substantive constitutional right rather than merely enforce that substantive right. The court reasoned that this not only exceeded Congress's powers, but that it violated the separation of powers set forth in the Constitution, in that Congress took upon itself the prerogative to interpret the First and 14th Amendments, which was the exclusive purview of the judiciary. Now, the result of this decision is that RFRA was unconstitutional as applied to the states. However, RFRA still applied to control the review of federal laws and policies that burden religion. Since the City of Bernie decision, many states have passed their own state law RFRA statutes to ensure strict scrutiny applied at the state level. However, only 21 states have RFRA statutes. So in most jurisdictions, the unfortunate reality for religious minorities and for religious liberty practitioners is that Smith is still the operative rule applicable to state and local governments that government actions that burden religious exercise. Nevertheless, there are a handful of what you might call workarounds to get around Smith and still trigger strict scrutiny. For example, strict scrutiny will still apply where a state action targets religion, even when the targeting is not explicit in the law. For instance, in the Lukumi Babalu case, the court struck down a local ordinance that outlawed the ceremonial killing of animals. This law triggered strict scrutiny because it was not a neutral, generally applicable law, but rather one that targeted religion. The law did not apply to secular animal slaughter, so the court found it was not a neutral, generally applicable law. Another example of where strict scrutiny still applies is where the government discriminates on the basis of religion. This was most recently demonstrated just a couple years ago in the case of Trinity Lutheran Church of Columbia versus Comer. In that case involved a Missouri program that gave state grants for resurfacing playgrounds. However, Missouri also has a Blaine Amendment. Remember those? Missouri's Blaine Amendment forbade any public funds from going to religious institutions. So when a Lutheran church and school applied for this grant from the state of Missouri to resurface its playground, the state forbade it from participating in the program, citing to its Blaine Amendment. So the church was in effect being denied a government benefit on the basis of its religious character. The Supreme Court held that this triggered strict scrutiny and ruled that the program could not discriminate against religious organizations. Now, an even more recent case, one that most of you are likely very familiar with, Masterpiece Cake Shop versus Colorado Civil Rights Commission. That case stands for the proposition that strict scrutiny is triggered when the government exhibits an overt hostility towards religion. So according to the majority opinion in the cake shop case, it wasn't necessarily unconstitutional that the law required Jack Phillips to create expressive wedding cakes for same-sex couples. But what did offend the First Amendment was the hostility and the disrespect that the Civil Rights Commission exhibited toward Mr. Phillips' religious beliefs in the administrative proceedings. So as you can see, even though Smith is still the operative test for free exercise claims against state and local governments, there are ways to circumvent Smith and to trigger strict scrutiny. Now, as just a practical overview of how you can analyze any free exercise issues that might come up in your own practice, the first question you want to ask is whether your client's religious exercise is being substantially burdened by the government. That is to say, is a law or government action putting your client in a position where they are being forced to choose between their religion and receiving a government benefit or evading a government sanction? The next question you want to ask is whether the law or policy that is burdening your client's religious exercise is from the federal government or from a state government. If it's federal law, then you have a RFRA claim and strict scrutiny applies. However, if the law that's burdening your client's religious exercise comes from state law or local law, you want to look first to whether the state has a RFRA statute or if the state's courts have interpreted its constitution to require strict scrutiny. So just FYI, Colorado does not have a RFRA, and courts here have essentially interpreted Colorado's constitutional provision to require no more scrutiny than Smith. If there's no applicable state law RFRA, then your best chance of victory is showing that the law being challenged is actually not neutral or generally applicable. So if your client's burden was caused by an individualized assessment, rather like an assessment from a state agency, rather than just a blanket regulation or a blanket law, then you might have a good argument that it's not neutral and generally applicable, and you can maybe get to strict scrutiny. However, if there's no RFRA and the law or policy is actually is neutral and generally applicable, then I'm afraid you're stuck in Smith world, and you'll have the onerous burden of proving that the state action burdening your client's religion has no legitimate or rational basis. Now, that's a tough row to hoe, but that's not to say it can't be done. Now, moving on from the free exercise clause to the establishment clause, this is also an area of constitutional law that's been rather dynamic and fluctuating in the past several decades. So like the free exercise clause, the establishment clause has seen most of its litigation in the past 60 years or so. However, in that short time, the Supreme Court has managed to sow as much confusion as it can into this clause by promulgating a plethora of different standards and applying them in a seemingly arbitrary manner. The court seems to oscillate back and forth between the various standards that it's created, all while never actually overruling any precedent. So there is no consistent or comprehensive test for establishment. Now, this uncertainty puts practitioners in a rather frustrating position because it requires them to conduct their analysis under each of the viable tests. So unless the judge in your case has a record of opinions or scholarly publications indicating his or her preferred standard for establishment clause analysis, or unless the facts of your case are just so identical to a previous case that it's manifestly clear which test applies, you almost have to cover all the possible bases. That is to say, if your client is arguing that a law is or is not in violation of the establishment clause, you'll need to argue your position under each of the possible tests a judge might apply. So that being the case, I think it's best to go through the various tests a court might apply so you can be prepared to make or respond to arguments that arise under each standard. Now, the first test for the Establishment Clause is the notorious Lemon test, first articulated by Chief Justice Berger in the 1971 case of Lemon versus Kurtzman. Now, under the Lemon test, there is a threefold requirement for a law to be constitutional. First, the law must have a secular legislative purpose. Second, the principal or primary effect of the law must neither advance nor inhibit religion. Lastly, the law must not result in excessive government entanglement with religion. Now, the Lemon test was in vogue in the federal courts throughout the 1970s and 80s, and the courts were excited to have what seemed to be a comprehensive, all-purpose analytical standard that would govern any possible scenario. I mean, that's what the test was formulated to be, a grand, unified, all-encompassing theory of the Establishment Clause. However, I think it's for that very reason that the test has fallen out of favor with many scholars and many judges in the past few decades. The Lemon test is so comprehensive that it's practically unworkable in many contexts. It was formulated to encapsulate the entire Establishment Clause forest, but it cannot practically manage the trees. Moreover, I think the Lemon test is simply too aggressive in practice to render results that are palatable for most Americans. If this test were applied consistently across the board to all government actions in America, past and present, it would require a dramatic revision of many American civic institutions. For instance, how could something like the chaplaincy in the military survive an honest application of the Lemon test? Nevertheless, despite multiple attempts to lay the Lemon test to rest in the Supreme Court, it always seems to resurrect and be applied when a court has a mind to strike down a particular law or policy. Justice Scalia famously said that the Lemon test, quote, haunts Establishment Clause jurisprudence like some ghoul in a late-night horror movie that repeatedly sits up in its grave and shuffles abroad after being repeatedly killed and buried. So love it or hate it, the Lemon test is still a thing, and it's a standard that courts are liable to dig up and apply. Now, another test is the so-called coercion test, which is the brainchild of Justice Kennedy. Now, the gist of the coercion test is essentially no harm, no foul. That is to say, if the government is not directly aiding religion in a way that constitutes an overt establishment, or actually coercing people to participate in religion against their will, then the Establishment Clause is not violated. Now, another test that has never actually been applied in any Supreme Court majority opinion, but that has enjoyed some support in the lower courts is Justice Sandra Day O'Connor's endorsement test. So like the Lemon test, the endorsement test looks at both the purpose and the effects of government action. However, unlike Lemon, the endorsement test focuses on whether the government has made one's adherence to a religion material to their standing in the political community. So according to Justice O'Connor, the essence of the Establishment Clause is that the government cannot send a message that makes citizens feel like insiders or outsiders of the body politic based upon their religion. Now, the next test, and one that I think, especially in the Roberts Court, is gaining the most traction for future Establishment Clause cases, is what you might call the historical approach. If you look at the previous three tests for establishment we've discussed, with each of them, there are traditions and practices in American civic life that would be rather hard to justify under any of these tests. These include things like legislative prayer or legislative chaplains, or the fact that many of our city governments bear the names of Catholic saints or have religious imagery on their official seals, or that our national motto is "In God We Trust." So these institutions are kind of difficult to reconcile with any of the Establishment Clause tests we've discussed heretofore. Therefore, the historical approach basically says, look, this looks very religious, but we've been doing it for so long that it has become part of our civic life such that it has taken on an added secular significance. So the logic, the constitutional logic of this is that if the generation of statesmen who framed and ratified the Establishment Clause were doing things like this, then they could not possibly have intended for these things to be unconstitutional. Now, of course, you'll recognize this approach presupposes an originalist interpretive method to the Constitution. Now, the last Establishment Clause theory I want to discuss is that which is postulated by Justice Clarence Thomas. Justice Thomas has a rather unique view of the Establishment Clause that, at least to my knowledge, no other Supreme Court justice in recent history has espoused. While it is very much a minority view, it's nonetheless very interesting. So put simply, Justice Thomas thinks that Everson versus Board of Education was wrongly decided, and that the Establishment Clause actually does not incorporate against the states. So Justice Thomas argues that the Establishment Clause should not be understood as protecting an individual civil liberty, but rather as a structural restriction on federal power vis-a-vis the states. So because the Establishment Clause does not protect an individual interest in life, liberty, or property, it is not implicated by the Due Process Clause of the 14th Amendment and does not apply against the states. So for Justice Thomas, the original, who is a staunch originalist, the original intent of the Establishment Clause is not to prohibit state establishments of religion, but rather to protect them. All right, so now that we've discussed both the Free Exercise Clause and the Establishment Clause, next I want to discuss a dimension of First Amendment religious liberty known as the abstention doctrine. Now, the abstention doctrine is, if you will, the filioque of the First Amendment, in that it proceeds from both the Free Exercise Clause and the Establishment Clause. The essence of the abstention doctrine is that secular tribunals must abstain from adjudicating religious or ecclesiastical disputes. Now, the classic example is a church property dispute, where contending factions of a congregation are each claiming a right to the property on the basis of their superior adherence to the church's official doctrinal standards. So insofar as an interpretation of religious teaching or an assessment of religious practice is dispositive of which faction will prevail, the court must abstain from adjudicating such a case. Now, the reason for this is that judges are not theologians, and they cannot constitutionally function as ecclesiastical arbiters, because that would offend both the Free Exercise and the Establishment Clause. Now, a kind of corollary dimension to the abstention doctrine in the world of employment law is what is known as the ministerial exception. The ministerial exception is a First Amendment doctrine that churches and religious organizations are exempt in many instances from otherwise applicable employment laws, but only in the employment of ministers. So while the ministerial exception has been recognized and applied in the state courts and in the lower federal courts for a very long time, it's only been rather recently that the exception was first recognized and applied by the U.S. Supreme Court, and that was in the case of Hosanna Tabor Evangelical Lutheran Church versus EEOC, and that was in 2012. That case involved a teacher at a Lutheran school who was terminated and who brought an employment discrimination action against the school. Now, the court in that case formally recognized the existence, excuse me, of the ministerial exception. And applying it to the plaintiff, the teacher in that case, ruled that she was indeed a minister and therefore her claims were barred. While the court expressly declined to adopt a rigid formula or test for determining whether an employee is a minister for purposes of the exception, the court did enumerate 4 considerations upon which it decided that the plaintiff in that case was in fact a minister. The court pointed to the fact that the school held the teacher out as a minister, that her job description reflected the fact that she was a minister, that the teacher herself held herself out to be a minister, and that her actual duties included important religious functions. So since the Hosanna Tabor decision, there's been a circuit split as to whether important religious functions alone is sufficient to establish ministerial employment, or whether an employer is required to prove additional facts in addition to important religious functions in order to establish that the employee at issue is a minister. So as we'll discuss in a moment, that's a circuit split that the Supreme Court is hopefully going to resolve this term. Okay, so moving on to the second part of our presentation, we'll now look at the recent and current religious liberty litigation in the federal courts, specifically the U.S. Supreme Court. So looking at last year's Supreme Court term, last term, the court decided 2 emergency petitions that involved religion. Now, these 2 cases are interesting because they are virtually the same factually, but nevertheless had 2 totally different results. Both of these cases involved death row inmates, one a Muslim in Alabama, and the other a Buddhist inmate in Texas, both of whom petitioned to have spiritual advisors with them in the execution chamber. Now, in both of these cases, the correctional facilities that were administering the execution routinely had a Christian chaplain in the execution chamber during executions. Each of these inmates petitioned to stay their execution until the facilities were ordered to permit them to have their own spiritual advisors present rather than the Christian chaplain. Now, in the first case, Dunn versus Ray from Alabama, the Supreme Court denied the stay and allowed the execution of the Muslim inmate to go forward with the Christian chaplain and no Muslim imam in the execution chamber. However, just weeks later, the court granted the stay for the Buddhist inmate in Texas and ordered the state of Texas not to execute the inmate until it had changed its policies to remedy the First Amendment violation. Now, in response, Texas stopped allowing any religious clergy or spiritual advisors in the execution room at all. So regardless of which of these 2 cases you think was decided correctly, the striking aspect to me is that they should have had the same result either way. The only explanation we have accounting for a material difference between these 2 cases is from a subsequent statement that was filed by Justice Kavanaugh after the order was issued, explaining that the reason that he voted for the stay in the Texas case, but not in the Alabama case, was because the Alabama inmate had not filed his petition in a timely manner. Now, you might find that explanation satisfactory, but as for me, I can't see why these 2 identical cases reached dramatically different results just weeks apart. Now, the only fully briefed and argued case that the court ruled on last term was American Legion versus American Humanist Association. That case involved a 40-foot tall Latin cross in Bladensburg, Maryland. The cross was erected in 1925 by the American Legion to honor local veterans who had fallen in the First World War. In 1961, the local government acquired the property on which the cross was located, and eventually, pardon me, eventually the cross found itself conspicuously situated in the center of a busy traffic median, where it had to be well lit at night for traffic safety reasons. So I think it was in 2017, a handful of local residents sued for an injunction that the cross be destroyed on the basis that it violated the Establishment Clause. Now, while the Supreme Court voted 7-2 that the cross did not indeed violate the Establishment Clause, there was no rationale or reasoning that won the support of enough justices to affect any real precedential value from this case. And the makeup of the various concurring opinions from the justices, I think, resulted only in a continuation of the confusion regarding the Establishment Clause that we discussed earlier. So I think the only positive rule that we can extract from this case is that the Lemon test does not apply to longstanding public monuments. But the decision did not actually overrule Lemon. Strangely enough, even though there were a majority of justices who expressly opined that Lemon should finally be killed off, the Lemon test miraculously survived this decision. This goes to show that the Lemon test is the Rasputin of First Amendment doctrines. It simply cannot be killed. Now, moving on to the court's present term, there are 4 religious liberty cases for which we can expect decisions to come down in the next few months. The first is Espinoza versus Montana Department of Revenue. This case involves a scholarship program for private school students enacted by the Montana legislature that gave a $150 tax deduction to citizens who donated to any private nonprofit scholarship organization. The scholarship organizations would then use these donated funds to award need-based scholarships to families who wanted to send their children to attend private schools, including private religious schools. However, the Montana Supreme Court struck down the program on the basis that it violated, you guessed it, Montana's Blaine Amendment. So a collection of low-income parents who were counting on the scholarship fund to send their children to private religious schools appealed the case to the U.S. Supreme Court, arguing that the Montana court's decision that religious schools could not receive scholarship funds under the program is the same kind of religious discrimination that was struck down in the Trinity Lutheran case. Now, this case is very important because it has the potential, I think, to strike down Blaine amendments in toto, or at least to significantly abridge their application. Now, the next case, FNU Tanzan versus Tanver, it's not a First Amendment case, it's a RFRA case. That case involves 2 Muslim men who allege that the FBI placed their names on the national no-fly list in retaliation for their refusal to become FBI informants on fellow Muslims. The 2 plaintiffs have asserted RFRA claims against the individual FBI agents who solicited them. And the issue before the court in this case is whether the federal RFRA statute permits actions for monetary damages against individual federal employees. The next case is actually a couple of companion cases, Our Lady of Guadalupe School versus Morrissey Baru and St. James School versus Beale. Both of these cases involved employment discrimination actions brought by teachers who were terminated from Catholic schools. And the issue in both cases is whether the teachers were ministers for purposes of the ministerial exception. As I mentioned earlier, this is the case that will hopefully resolve a circuit split as to how courts should determine if an employee is a minister, whether the employer's burden is simply to show that the employee has important religious functions, or if more elements are required in order to apply the ministerial exception. The last religious liberty case this term is also a set of companion cases, Little Sisters of the Poor versus Pennsylvania and Trump versus Pennsylvania. These are very complicated cases with a very long procedural history. They involve complex matters of administrative law. I won't go into the details of the case, but the central issue is whether federal agencies had statutory authority to expand conscientious and religious exemptions to the contraceptive coverage mandate of the Affordable Care Act. All right, so we've looked at the religious liberty cases the Supreme Court decided last term, as well as the cases it will decide this term. Next, we'll look at what cases are on the horizon for the court's next term. So the court has already denied cert in a case, Archdiocese of Washington versus Washington Metro Transit Authority. In this case, the Archdiocese applied to the Transit Authority to have a religious Christmas advertisement on public buses in DC. The Transit Authority ran all kinds of Christmas ads on their buses for Macy's and lots of other businesses, but it had a policy against religious advertisements. So the diocese sued under both the First Amendment and RFRA, arguing that the Transit Authority's policy was discriminating against religious viewpoints. But both the district court and the DC Circuit ruled in favor of the Transit Authority, and the Supreme Court unfortunately denied certiorari. However, the Supreme Court granted cert in a very important case from the Third Circuit, and that case is Fulton versus City of Philadelphia. Now, in that case, Catholic Social Services had operated a foster care ministry in Philadelphia for many years, placing children in foster homes. But in 2018, the City of Philadelphia barred Catholic Social Services from placing children in foster homes because of its faith-based policy of not licensing same-sex couples to be foster parents. So Catholic Social, pardon me, Catholic Social Services sued the City of Philadelphia, asking the court to order the city to renew their contract. Now, applying the rule from Employment Division versus Smith, both the district court and the Third Circuit ruled against Catholic Social Services on the basis that the city's non-discrimination policy was a neutral, generally applicable law that bound foster care agencies irrespective of their religious affiliation. However, there's a circuit split as to what a party must show in order to prevail on a free exercise claim under Smith. In the Third Circuit, a plaintiff must show that the government actually treats similarly situated parties of different religions more favorably. Of course, under that standard, Catholic Social Services cannot make a viable free exercise claim. But other circuits, including the 10th Circuit, allow courts to consider extrinsic evidence that a law or policy was intentionally discriminatory against religion, even if it is not facially so. So this case presents an excellent opportunity for the court to revisit Employment Division versus Smith, either to overrule it and return to the old strict scrutiny standard, or to at least adopt a reading of Smith that is much more accommodating for religious minorities. Now, there's another case with a cert petition that's still pending, Ricks versus Idaho Contractors Board. That case is also asking the court to revisit Smith. That case involves a contractor who objects on religious grounds to using his social security number on an application for a state contractor's license. And he requests that the state accommodate his objection by accepting his birth certificate instead. Honestly, I'd be quite surprised if the court grants cert in this case, but if they do, it might be a companion case to the Fulton case. So regardless, the next two Supreme Court terms are going to be very crucial for religious liberties. Now, the last item I want to discuss is the elephant in the room. And of course, that is the litigation associated with the COVID-19 social distancing orders. Now, as of this morning, I have read 18 federal court decisions on deciding challenges to state orders that prohibit religious gatherings. Now, those are what I'm able to access on Westlaw. There are probably some more, there might be some more that haven't made their way onto Westlaw yet, but so far only 6 of those 18 decisions have been victories or partial victories for religious plaintiffs challenging orders restricting worship services. Now, there have also been a handful of cases that are not included in this list, in which the government backed off of their orders restricting drive-in worship services after a lawsuit was filed, and either the plaintiffs withdrew their complaint or filed a voluntary dismissal, or they the court entered an agreed order. So those cases aren't listed in the handout materials. I have a list of all those cases in the dispositions if you want to see those. Those cases, the only cases I have listed are those in which a federal court ruled on a live and hostile challenge to orders restricting religious gatherings. But there are enough decisions on the books now to see some trends emerging. The first trend we're seeing is an almost total split between how Republican-appointed judges are ruling on these as opposed to Democratic-appointed. The former are taking a posture much more suspect of government orders, and the latter are being much more deferential to the government. Now, I'm in no way insinuating that any of these judges are politically dependent or that they have any kind of political agenda, but there is a conspicuous trend here. Of course, there are a couple of exceptions to this. Judge John Mendez over on the Eastern District of California upheld California stay-at-home orders, and I think there was a Trump-appointed judge here in the District of Colorado that upheld the challenge as well. But I think that was more on standing issues. The second trend we see is that judges are much more willing to strike down orders against drive-in services than they are to strike down orders barring in-person services. So prohibition of drive-in services are much less constitutionally defensible, especially when secular drive-ins like fast food restaurants are permitted to operate. A third trend is the difference between orders that have a specific application to religious gatherings and orders that are generally applicable but apply to religious services. Now, as we discussed before, the rational basis rule from Smith does not apply where religion is being targeted by a government policy. A good example is the decision that struck down the Kansas governor's order. The governor of Kansas, her first stay-at-home order originally exempted churches, but then she turned around and issued a subsequent order that intended to reverse that exemption. And that order applied only to religious gatherings. So the judge in that case found that this targeting of religion was the fatal flaw constitutionally of the Kansas order. Finally, a trend we're seeing is that while most of the plaintiffs in these cases are churches, some of the cases where individual worshipers were the plaintiffs have been dismissed for lack of standing. A handful of courts are reasoning that the individual plaintiffs are not able to allege that but for these orders, their churches would still be open and they could attend. And therefore, the necessary elements of traceability and addressability are missing, and they don't have Article III standing. So what are the arguments that religious plaintiffs are making in these cases? Well, as you may have surmised from our discussion, the key to winning a free exercise case is to get around Smith, to get out of the realm of rational basis review and to trigger strict scrutiny. So plaintiffs are trying to do that in a couple different ways. First, they're pointing out the plethora of secular exceptions for things like grocery stores, liquor stores, hardware stores, to show that the orders are not neutral laws or generally applicable, and that they are not entitled to a presumption of constitutionality under Smith. Second, where there are state law RFRA statutes, plaintiffs are relying on those to get to strict scrutiny. Now, of course, even if strict scrutiny does apply, the containment of a deadly virus arguably does constitute a compelling state interest. However, as you recall, under strict scrutiny, a policy must be narrowly tailored. It must be the least restrictive means of achieving the state's compelling purpose. The argument plaintiffs are making is that is persuading some courts is that the orders that impose a blanket prohibition on religious gatherings are not the kind of narrowly tailored, least restrictive means that is required to satisfy strict scrutiny. To quote one federal judge, Judge Van Tatenhove over on the Eastern District of Kentucky, in his opinion striking down Kentucky's ban on in-person worship, If social distancing is good enough for Home Depot and Kroger, it is good enough for in-person religious services, which, unlike the foregoing, benefit from constitutional protection. Now, turning to the other side of the V, what arguments is the government making? Well, of course, the most basic argument is under Employment Division versus Smith. Most of the stay-at-home orders, unlike the one in Kansas, that are in place, are neutral, generally applicable laws that are not specific to churches, but ban all gatherings, religious and secular. Therefore, only rational basis review applies, and the state can very easily meet this standard in the midst of a pandemic. But what about in states that have RFRA statutes or that otherwise have a strict scrutiny standard on the state level? Well, governors and local officials are arguing that they have a compelling interest that satisfies strict scrutiny, and pardon me, and that their compelling purpose cannot be achieved if churches get an exemption from these orders. However, beyond the proposition that the stay-at-home and social distancing orders satisfy the demands of strict scrutiny, many of the cases that are upholding these orders against First Amendment challenges are doing so on grounds that are distinct from the traditional tiered scrutiny analysis altogether. So two very old U.S. Supreme Court cases are now being cited to in these district court opinions to stand for the proposition that the First Amendment is effectually set aside or greatly diminished under emergency circumstances like this. The first case is Jacobson versus Massachusetts. It's a 1905 case. This was a case that ruled that the state of Massachusetts could require compulsory smallpox vaccinations. This case has quite a bit of language in it that is, frankly, nails on a chalkboard for civil libertarians. And the case is being cited for the proposition that constitutional rights take a back seat to public health when the state is, quote, under the pressure of great dangers. Now, the second case that is being cited in all these coronavirus decisions is the 1944 case of Prince versus Massachusetts. That case involved a constitutional challenge to child labor laws by Jehovah's Witnesses who were fined for essentially forcing children to go onto the streets and preach. So the court in Prince ruled that the right to practice religion did not override the state's police powers to ensure the health and welfare of children. Now, the dicta from Prince that is now being quoted and cited to in the current litigation is the proposition that, quote, the right to practice religion freely does not include liberty to expose the community or the child to communicable disease. Now, the briefing from the government in these cases is replete with reliance on these two cases, and most of the decisions upholding these orders against First Amendment challenges are to varying extents relying on these cases, particularly the Jacobson case, for the proposition that the entire due process and equal protection framework of scrutiny is essentially set aside under these circumstances. To quote one of the district court opinions, quote, while such an epidemic is ongoing, the traditional tiers of constitutional scrutiny do not apply, end quote. Now, many of these courts are reading and applying Jacobson to effectually create a fourth category of judicial scrutiny under which state police powers during a public health crisis are augmented beyond their normal accountability to tiered scrutiny. Now, admittedly, this is quite concerning. That there are governors and attorneys general and even federal judges who see the First Amendment religious liberty as a sort of fair weather right that can be dispensed with under certain exigencies. Fortunately, the U.S. Department of Justice under Attorney General Bill Barr is getting very actively involved in this litigation and has made itself very clear that it will oppose any excessive state encroachments on religion. Well, ladies and gentlemen, this concludes my presentation. I hope you've enjoyed and benefited from the information I've shared with you. I know our hour is up and many of you will need to return to work, so feel free to take your leave. But I'm happy to open the floor for any questions you guys might have.